So in fiscal year 2025, the EEOC obtained roughly $660 million in funds for employees.
Which is just a staggering number to even wrap your head around.
Right, and get this. More than half of the 88,531 new charges filed that year included some type of retaliation claim.
Yeah, that is the really scary part. More than half.
Exactly. So today we are doing a deep dive into this hidden danger zone in the workplace. And I'm talking directly to you, the listener, whether you're a middle manager, a seasoned executive, or really just anyone trying to navigate corporate dynamics.
Because the reality is, even with the absolute best intentions, and even if your company has, like the most perfectly drafted anti-harassment policies sitting on some server routine management decisions, are quietly creating massive legal liabilities.
Yeah, the sheer volume of those EEOC charges tells a very specific story, right?
Oh, absolutely. It tells us that organizations are systemically failing. And not necessarily in how they prevent the initial bad behavior, but in how they react once that behavior is actually brought to light.
Right, the reaction is the issue.
Exactly. The retaliation charge is often the piece that survives all the way to trial, even if the underlying complaint, like, say, a claim of discrimination, gets entirely dismissed.
That is wild. Which actually brings us to the source material we're working with today. We're pulling from a standing room only session at the SHRM 26 conference.
The Society for Human Resource Management.
Yes, exactly. That took place on June 18th, 2026. And the notes from the session paint a very vivid picture. Like, attendees were literally lining the walls of the room.
I read that the speaker actually had to pause the presentation to tell people, hey, if you have an empty seat next to you, raise your hand.
Right, just so the professionals crammed by the doors out in the hallway could finally sit down.
Which, I mean, that kind of attendance at an industry conference speaks to the absolute urgency of the topic.
Oh, for sure. Everyone in that room knows that retaliation is the silent killer of corporate budgets, and they are desperate for a framework to stop it.
So the speaker leading that session was Louis R. Lessig. He's a partner at the law firm of Brown & Connery, LLP, and he's known professionally as the Employment Law Translator.
I really love that title, by the way, because, let's be honest, the law can be incredibly opaque.
Very much so. But Lessig brings this fast-talking, really high-energy approach, and he has a very unique vantage point.
Yeah, because he represents employers in both the boardroom, advising them on defensive strategy before things go wrong, and in the courtroom, defending them when things inevitably do go wrong.
Plus, he has an operational background, which is critical for translating these concepts. He isn't just some attorney coming down from the mountain to lecture management about abstract theories,
Right. He actually understands the day-to-day operational realities, the stresses of running a department.
Exactly. And the very human reactions that managers have when an employee files a grievance.
So his central thesis completely flips how most of us think about workplace conflict. Lessig argues that retaliation claims are rarely about what happened before a complaint is raised.
They're almost entirely about what happens after.
Okay, let's unpack this, because most employers operate under this false sense of security, don't they?
Oh, absolutely. They believe they can prevent retaliation by simply having a robust policy, doing their mandatory annual training, and, maintaining a standard investigation process.
Check the compliance boxes and assume the liability shield is up.
Right. But the real danger zone is that post-complaint period. It's the subtle shifts in behavior, the reactive course corrections, or even just the changes in tone in a manager's emails.
So to really grasp how these subtle changes turn into multi-million-dollar lawsuits, Lessig says we have to undergo a complete mindset shift.
Yes. Before we even get into the mechanics of where companies mess up, we
Yeah.
really have to look at who's ultimately judging those mess-ups.
Right, and Lessig introduces this golden rule for navigating this danger zone, which is you have to think like a jury.
Think like a jury. I love that. You have to leave your management hat, your HR hat, and your protect the company at all costs hat at the door.
It's a fundamental paradigm shift.
Right.
Because when an employer makes a decision regarding an employee, they're usually evaluating it based on their own internal logic, right?
Right. A manager might ask, does this follow our standard operating procedure? Or does this align with our corporate culture?
Is this the most efficient way to run my department?
Exactly. But if a retaliation claim goes the distance and actually ends up in court, the people judging that management decision are not corporate executives.
No, they're 8 random people sitting in a jury box.
Precisely. They're everyday citizens who likely do not know your business at all. They don't understand your industry jargon.
And they definitely don't care about your internal standard operating procedures or your quarterly goals.
Not even a little bit. As Lessig bluntly points out, they're probably just sitting there frustrated that they got pulled for jury duty. They're making their minimal daily stipend.
Right.
And they're viewing the facts through a single, uncompromising lens, which is fairness. Yeah. If a corporate decision does not pass the basic common sense smell test of fairness to an outside observer, the employer is going to lose.
Okay, I want to push back on this for a second on behalf of the listener, especially for those sitting in compliance or HR roles right now.
Sure, go for it.
So, if a company implements a strict zero-tolerance anti-retaliation policy and they make every single employee sign an acknowledgement of that policy, isn't that enough?
You think so, right?
Right. If you put up the guardrails and strictly forbid managers from retaliating, can't you just point to the policy in court and say, hey, look, we told everyone not to do this. We're not liable for a rogue manager.
It's a very common defense mechanism. Organizations constantly attempt to hide behind their paperwork. But a policy on a piece of paper does not control human nature.
Obviously not.
I mean, we've had mandatory EEO training for decades. If policies and training modules actually prevented human behavior, the EEOC wouldn't be securing hundreds of millions of dollars a year for plaintiffs.
Because a piece of paper doesn't control a supervisor's ego when they feel, challenged by an internal investigation.
Exactly. The paper doesn't control the severe frustration a manager feels when an HR investigation completely disrupts their workflow during a crucial quarter.
That makes a lot of sense.
When you're standing in front of a jury defending a termination, you can't just point to page 42 of the employee handbook and say, well, we have a rule against it, therefore the company is innocent.
Right. The jury is looking right past the handbook. They're looking at the actual human behavior of the leaders in your organization. They're asking, did this manager get angry and punish this employee?
Exactly. And the attendee feedback from SHRN 26 really highlights how effective this framing was.
Oh, yeah. People describe the session as work-life changing. Someone even called it the best counsel HR conference presentation yet.
Because it took this terrifying, amorphous legal threat and made it incredibly tangible.
Yeah. When you train your managers to literally stop before sending an email or issuing a disciplinary notice and ask, how would 8 random strangers view what I'm about to do, it acts as a circuit breaker.
It short-circuits that immediate, emotional, reactive response. It forces a necessary pause.
Right. And to guide leaders through that pause, Lessig introduces a 5-step framework. He calls it the post-complaint decision chain.
The decision chain. And it basically maps out the series of dominoes that fall from the moment someone raises an issue to the moment a jury hands down a verdict.
Okay, let's start with the very first domino. Step 1 in the decision chain is awareness.
Awareness, yes.
And this isn't just about a manager knowing that an employee filed a formal complaint. The core concept here is identifying who actually engaged in protected activity.
And this step reveals a massive blind spot for most organizations. Because when a complaint is filed, say for sexual harassment or age discrimination, the company hyper-focuses on the person who filed the complaint.
Right, they put up a protective wall around the complainant.
But the retaliation risk often extends far beyond that primary individual.
It's the collateral damage.
Exactly. The witnesses. The colleagues who are pulled into the investigation to corroborate a story.
Right.
Any employee who participates in an investigation or supports a colleague's complaint is also engaging in legally protected activity.
Okay, let's ground this in the real-world case Lessig presented because it illustrates this blind spot perfectly. It's the Custer v. WNAM-TV5 case.
Oh, this is a classic example.
So we have Custer, who is a veteran local television anchor. The presentation describes him as the local equivalent of a Peter Jennings.
A highly respected, established, trusted face of the network.
Exactly. He is not the disgruntled employee. He's not the one with a grievance.
Right. A coworker of his raises a workplace complaint. And because a formal complaint was made, the company initiates an investigation.
Naturally.
And as part of that investigation, management approaches Custer and asks for his perspective on the coworker's claims.
Which puts Custer in a very awkward position, but he does what a professional does. He participates.
He gives candid, honest statements supporting his colleague.
He tells the investigators the truth about what he witnessed. He's essentially just following the company's own policy to cooperate with internal investigations.
He cooperates fully. But the internal reaction to his cooperation is a massive failure of management awareness.
Because the senior managers did not want to hear what he had to say.
Not at all. We can infer the psychological environment here. Management is likely defensive about the underlying complaint. They're hoping the investigation will quietly exonerate them, right?
Or just find no wrongdoing. And suddenly, their star anchor, a highly credible witness, validates the whole complaint.
So the management team feels cornered. And instead of accepting the findings and actually fixing the workplace issue, they turn their frustration on the witness.
They terminate Custer, they fire their Peter Jennings.
And Custer immediately sues for retaliation. The result: a jury awarded him a six-figure sum.
I mean, put yourself in the jury box for this one. The company was entirely focused on the original complainer. They completely forgot that participating in an investigation provides the exact same legal protection.
It does. And how does a jury perceive a company that fires a respected employee just for answering an investigator's questions honestly?
To a jury, it looks like corporate thuggery.
It really does. It looks like the company is silencing witnesses to protect bad actors in upper management.
The jury sees an honest employee who is just trying to help a colleague and follow the rules, and the corporation just crushes him for it.
Right. Juries are inherently skeptical of large institutions to begin with, so when an institution fires a truth teller, it is incredibly easy for the jury to channel their outrage into a massive financial penalty.
Wow. So the primary takeaway from the awareness step is that you must train managers to protect everyone in the blast radius of a complaint.
Exactly. If an employee is interviewed by HR or, provides an email to an investigator, management needs to understand that that person now wears a protective halo,
You cannot discipline them without intense scrutiny.
which requires organizations to ask a really difficult operational question. Do your frontline managers actually know who is participating in an investigation?
That's a great point, because often HR keeps investigations highly confidential.
Right. But if a manager doesn't know an employee is protected and they fire that employee for an unrelated minor infraction, the company still steps on a retaliation landmine.
Awareness has to be managed incredibly carefully.
It really does.
Okay, so the complaint has been made, the witnesses have been interviewed, management is fully aware of who holds protected status. That brings us to the second link in the post-complaint decision chain. Step 2, adjustment.
Adjustment. This is where human nature really starts to poison the operational well.
The core question management must ask here is, what changed after the complaint?
Right. Because once a manager is aware that an employee has filed a complaint or supported one or taken protected leave, the dynamic shifts.
Sometimes it's a blatant, aggressive shift, but more often it's a series of incredibly subtle, almost unconscious changes in how that employee is treated.
We're talking about shifts in timing, shifts in tone, and most dangerously, shifts in documentation.
Yes, a manager who used to walk by an employee's desk and say good morning suddenly stops making eye contact.
Or an employee who used to be allowed to log on 5 minutes late without an issue is suddenly receiving formal written warnings for tardiness.
Let's dive into the Boyle v. Wayfair LLC case, because the mechanics of this case are just a masterclass in the dangers of adjustment.
Oh, this case is fascinating.
So Boyle was hired as a senior manager at Wayfair, and according to the case facts, she was not a stellar employee. She admittedly had performance issues before she ever took a leave of absence.
That is such a crucial detail. We are not talking about a perfect employee who suddenly became a target. We have a documented underperformer.
Right. Then she requests and goes out on Massachusetts paid family and medical leave.
Let's pause to establish the legal context here, because taking protected medical leave triggers the exact same anti-retaliation protections as reporting sexual harassment.
You are engaging in a legally protected activity.
Exactly. But Massachusetts law goes a step further. They have a strict provision regarding the timeline.
The presumption of retaliation.
Yes. Specifically, if an employer takes an adverse employment action against an employee within 6 months of that employee returning from leave, the law automatically presumes the action was retaliatory.
That is a massive hurdle for a company. A legal presumption means the court automatically assumes the company is guilty of retaliation unless the company can prove otherwise.
The burden of proof completely flips. In a normal case, the employee has to prove they were retaliated against. Here, the company has to prove they didn't do it.
And they don't just have to provide a plausible excuse, right?
No, they must provide clear and convincing evidence to overcome that presumption. And in the legal world, clear and convincing is a very high bar.
Meaning, the evidence must be highly and substantially more likely to be true than untrue.
Right. It's not quite beyond a reasonable doubt, like in criminal court, but it's much heavier than the standard civil burden.
Okay, so keeping that heavy legal burden in mind, let's look at the timeline. Boyle returns to work from her medical leave. And how does Wayfair adjust their management strategy?
Immediately upon her return, they place her on a 45-day performance improvement plan, a PIP.
Immediately. And when she presumably fails to meet the aggressive metrics of that PIP, they terminate her.
Yep. And the jury looked at that sequence of events, and they awarded Boyle $4.7 million.
$4.7 million over an employee that the company could likely prove was underperforming before she ever left.
I know, it sounds crazy from a management perspective.
If I'm a manager listening to this, I am tearing my hair out. I mean, if you have an employee who is genuinely measurably bad at their job before they take medical leave, shouldn't you be able to fire them when they get back?
It's a completely logical frustration.
Why does taking leave grant them this magical, impenetrable shield against being held accountable?
The manager's thinking, well, she was failing before, she's still failing now, we need to move on.
Exactly.
But we have to return to Lessig's golden rule. Think like a jury. Strip away the corporate frustration and look at the timeline through the eyes of 8 strangers.
She goes on medical leave, she comes back, and boom, she is immediately handed a rigid 45-day PIP that leads directly to her firing.
To an outsider, the optics are just terrible. It looks highly suspicious.
It looks like the company was just waiting in the weeds. They couldn't fire her while she was in the hospital bed, so the second she walked back through the doors, they ambushed her with a PIP to create a paper trail.
Exactly. It looks entirely vindictive. And here is where the adjustment phase failed so catastrophically.
How so?
If she was truly a terrible employee before she left, the company should have had an airtight, heavily documented file on her before she ever requested the leave.
The documentation justifying termination must exist independently of the protected activity.
Right. The critical mistake was adjusting their timeline accelerating straight to a severe PIP and termination right on the heels of her return.
And Lessig emphasizes that the vast majority of that $4.7 million verdict was not compensatory damages. It was punitive damages.
The jury wasn't just replacing Boyle's lost wages. They were actively punishing Wayfair.
Because the jury read the law, they were instructed by the judge regarding that 6-month window of presumed retaliation, and they felt the employer arrogantly ignored it.
The rapid timing of the adjustment is what completely destroyed the company's defense.
So the actionable lesson here is not that you can never, ever fire a bad employee who took leave.
No, of course not. The lesson is that your documentation and your disciplinary timeline cannot look like you adjusted your behavior specifically because they took leave.
If you are going to terminate them, it has to be a natural, inevitable continuation of a rigorous, well-documented process that began long before the leave was requested.
Or, alternatively, you have to wait out the presumption window while meticulously documenting entirely new, separate failures without changing your management tone.
Right. Documentation is the paramount concern during the adjustment phase, and it works both ways, doesn't it?
Oh, absolutely. If a manager suddenly starts writing an employee up for minor infractions that were previously ignored, that is a retaliatory adjustment.
Or if a manager's tone in performance reviews goes from needs improvement but shows potential to completely incompetent immediately after a complaint.
A jury will see that adjustment as retaliation every single time.
Okay, so we have awareness and we have adjustment. The tension in the workplace is now palpable. The manager knows about the protected activity. They have adjusted their behavior by hyper-scrutinizing the employee, and the employee absolutely feels that shift.
But pressure built.
Which forces us into step 3 of the post-complaint decision chain. Action.
Action is where the internal frustration finally boils over into a tangible employment decision.
This is the moment manager decides, I cannot deal with this anymore. I am going to do something.
The core question leaders must ask themselves here is, what action am I considering and why?
Exploring the why takes us into the psychology of management. Because it's rarely a cartoonish scenario where a manager strokes an evil mustache and plans to ruin someone's life, right?
It's usually driven by a phenomenon Lessig calls complaint fatigue.
Complaint fatigue. It's a deeply human, deeply problematic psychological reality in management.
To really understand how it triggers catastrophic actions, we need to look at the case of Robinson v. Town of Marshfield.
The facts of the Robinson case are fascinating. So Robinson was the fire chief of the department, a respected veteran, a leader with significant tenure.
And his niece joins the fire department as a trainee cadet.
Right. And over time, she starts experiencing severe challenges with her training. Specifically, she raises issues that she feels are gender-based. She notices that male trainees are receiving different treatment, maybe more favorable assignments or extra help from the training officers, while she is being marginalized.
So we have a textbook gender discrimination issue brewing. And her uncle, the fire chief, decides to step in.
He acts as a proxy complainant. He starts raising questions with the town administration. He brings the issues to light on behalf of his niece.
Now, if we look at this in a vacuum, you have a senior leader identifying a potential civil rights violation in his department and reporting it to the town.
You would think the town administration would be grateful. They would want to address the sexism and protect the municipality from a lawsuit.
But that is not how bureaucratic systems often react when challenged.
No. How does the town actually react to the fire chief making noise about gender discrimination?
Just 10 days after he starts complaining, an ethics investigation is mysteriously launched against him.
10 days.
Yep. And then 20 months later, the town administration simply refuses to renew his contract. They push him right out of his leadership role.
The timeline is damning.
Yeah.
And the financial fallout for the town. The jury awarded Robinson $1.3 million.
Let's unpack the psychological mechanics of why the town administrators acted that way. And Lessig uses this brilliant analogy here. He compares management's reaction to the teacher from the Peanuts cartoons.
Charlie Brown's teacher. Wah, 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 wah.
Yes, it is the perfect audio representation of tuning someone out.
When an employee, or in this case a fire chief, keeps raising issues, keeps sending emails, keeps asking for meetings to discuss grievances, the administrators eventually stop listening to the actual substance of the complaint.
The cognitive load becomes too heavy. They have budgets to balance, a town to run, political fires to put out.
And here's this chief constantly demanding attention for this training issue.
Right. So eventually all they hear is the noise.
Yeah.
They get complaint fatigue.
And when complaint fatigue sets in, the entire goal of management shifts fundamentally.
It does. The goal is no longer how do we investigate and solve the underlying gender discrimination issue. The goal becomes, how do we make the noise stop?
They stop viewing the sexism as the problem, and they start viewing the fire chief as the problem.
They just want to silence the person who is causing them a headache, so they take action.
They launch a sudden ethics investigation, not necessarily to find truth, but to discredit him, to put him on the defensive.
Then they weigh out the clock on his contract and sever ties. Internally, they likely convinced themselves they were making a sound business decision.
They probably said things like, oh, he's become too disruptive, or we need a leader who aligns better with our administrative goals.
But if we connect this back to thinking like a jury, the jury does not care about the town manager's administrative goals.
Or how annoyed they were by the chief's emails. The jury looks at the facts. A respected fire chief, essentially a local hero, stands up for his niece who is facing sexism. And the town officials orchestrate a witch hunt 10 days later to silence him.
It is a devastating narrative for the defense. And what is truly fascinating and terrifying for organizations is that management frustration actually creates significantly more legal risk than the original complaint itself.
I really want to highlight that because it is a massive takeaway. Management frustration creates more risk than the original complaint.
Think about the neurological reality of a frustrated manager. When leaders act out of annoyance, when their patience is just totally depleted by complaint fatigue, their decision-making centers shift from logic to emotion.
Their actions lose all defensible business logic.
They become sloppy. They rush investigations. They skip steps in the disciplinary process.
And sloppy, emotionally driven actions look incredibly punitive to a jury.
The jury doesn't see a tired manager. They see a vindictive corporation, which is exactly why it leads to million-dollar payouts.
Which flows perfectly into step 4 of the post-complaint decision chain, articulation.
Articulation. This is where it all comes together.
You were aware of the complaint. You adjusted your behavior in response. You took an aggressive action out of sheer complaint fatigue. And now, you are sitting in a courtroom.
You're on the witness stand under oath.
The plaintiff's attorney is pacing in front of you, and 8 jurors are staring a hole right through you. You have to articulate your reasoning.
The core concept of articulation is answering the question, how will I explain this decision to an outside observer?
This is the ultimate unforgiving test of defensible business judgment. It's where the internal corporate logic is dragged into the harsh light of a courtroom.
Let's bring in the case of Miller v. County of Orange to see what happens when that internal logic collapses on the stand. Because this case shows the absolute worst-case scenario when a company literally cannot articulate a reason for their action.
The Miller case is really striking because of the environment it took place in. Miller was a former assistant county prosecutor.
She was an attorney herself, working for the government, ostensibly surrounded by people who understand the law.
Exactly. She witnessed overt, numerous forms of harassment directed at other women in her office. So she did what a prosecutor is trained to do. She reported the bad behavior. She went to HR and filed a complaint.
She stuck her neck out to protect other women. And how did her legally trained colleagues respond?
With severe, immediate retaliation. Two particular prosecutors began actively undermining her. They belittled her in meetings, yelled at her, and made it impossible for her to effectively do her job.
The work environment became incredibly toxic.
The pressure was so intense that at one point Miller actually withdrew her formal complaint, presumably hoping the retaliation would stop if she just backed down.
But backing down never works once the retaliation machine starts. Withdrawing the complaint didn't save her job.
No, the County of Orange fired her anyway.
And here is the absolute kicker, the detail that makes any defense attorney want to quit on the spot. When this case inevitably went to trial, the employer, the County of Orange, had no justification for firing her. None.
They could not articulate a single valid, documented business reason for why they let her go.
They had no performance reviews showing a decline in her legal work. They had no documented insubordination. They had nothing but the timeline.
She complained, she was harassed, she withdrew the complaint, and she was fired.
Because the Ashoan County could not articulate a legitimate reason, the jury found for Miller to the tune of $3 million. And again, a massive chunk of that award was designated as punitive damages.
Lessig ran an interactive poll during his SHRM 26 session that cuts right to the heart of this issue. He asked the audience of HR professionals, which matters more to you, being right or being able to prove you were right?
It is a profound, paradigm-shifting question. In the eyes of the law, and certainly in the eyes of a jury, being right in your own head is entirely worthless if you cannot prove it with objective evidence.
It's not enough for a manager to get on the witness stand and confidently say, well, she violated a policy, or she just wasn't a good fit for the culture anymore.
Because the plaintiff's attorney is immediately going to ask, okay, show me the other people you fired for not being a good fit.
Exactly. You have to be able to articulate with a pristine paper trail that you handled her situation exactly the same way you have handled identical situations with other employees who never filed a complaint.
It is known as the consistency test.
If you fired the complaining employee for being 5 minutes late, you better have a giant stack of HR files showing you have consistently fired every other employee who was 5 minutes late.
If you don't have that comparative framework, your articulation fails completely.
Because if a manager cannot articulate a consistent, logical, documented reason for a termination, the jury is going to fill in the blank.
Human beings abhor a vacuum. The jury will invent their own reason for why the employee was fired.
And I guarantee you the reason the jury invents will always be retaliation.
Always. They will look at the timeline, see the protected activity, see the unexplained firing, and connect the dots in the most damning way possible for the employer.
If you cannot articulate the business reason clearly, consistently, and with comparative evidence, you simply cannot take the action. You have to pause.
Which brings us to the final chilling link in the post-complaint decision chain. Step 5. Aftermath.
The aftermath. This is where we move past the poor management decisions, the sloppy documentation, and the failed courtroom testimony, and face the actual devastating consequences.
The core concept here is simply, how do I manage what happens next?
And when a company has failed the first 4 steps, when they lacked awareness, made punitive adjustments, acted on complaint fatigue, and couldn't articulate a defense, the aftermath is usually total financial devastation.
We're talking about the true hammer of the legal system, punitive damages.
The case Lessig uses to illustrate this, Graham v. Bristol Hospice Holdings, Inc., is the ultimate cautionary tale of corporate arrogance.
It truly is. Because in this case, Graham was not a frontline worker or a sales rep. She was an HR professional.
Wow.
She was one of the very people whose entire job description is to ensure compliance and prevent these legal issues from happening.
I have to pause on that. The company went after their own HR person.
Yes. Graham supported the claims of a coworker who had filed a complaint, and in response to her support, the company subjected her to inconsistent treatment.
Unbelievable.
She was suddenly accused of various workplace infractions, but crucially, she was not allowed to respond or defend herself against those accusations.
So, like Miller in the previous case, Graham felt the pressure, filed a charge, eventually withdrew it, and was ultimately terminated.
The irony here is thick enough to cut with a knife. A company retaliating against an HR professional is a uniquely dangerous game.
Lessig points out this danger perfectly. He says, HR knows where every dead body is buried.
It's a dark analogy, but it captures the reality of the organizational power dynamics so well.
HR professionals know the employee handbooks inside and out. They know the legal precedents.
And more importantly, they know the secret exceptions management has made in the past. They know about the executive who was allowed to quietly resign instead of being fired for cause.
They know exactly how the company is supposed to operate, and they know exactly when the company is breaking its own rules to target someone.
So when Bristol Hospice Holdings decided to retaliate against Graham, they were just picking a fight with an employee. They were picking a fight with the one person who held the map to all of their corporate skeletons.
She knew exactly how to prove they were violating the consistency test.
And what was the financial aftermath of picking that fight? A jury verdict of more than $5 million.
$5 million for retaliating against the person trying to keep the company compliant. Let's really delve into the mechanics of that $5 million. Why do juries award such astronomical punitive damages in the aftermath phase?
During his presentation, Lessig polled the audience on what actually triggers punitive damages, and the overwhelming correct answer is organizational indifference and deliberately bad decisions.
We really need to distinguish between the types of damages here. Compensatory damages are meant to make the victim whole, to literally compensate them for lost wages, medical bills, or proven emotional distress.
It's a mathematical calculation of what the employee lost.
Correct. Punitive damages, however, have nothing to do with compensating the victim.
No, punitive damages are a hammer wielded by the jury. They are designed to punish profound corporate arrogance and deter future bad behavior.
If a company is foolish enough and arrogant enough to silence and fire the exact professional whose job it is to ensure legal compliance, the jury is going to send a very loud, very expensive message.
The jury uses the punitive award to say, you cannot operate this way, and we are going to fine you an amount that actually hurts your bottom line so you never do it again.
So we have walked through the entire post-complaint decision chain. Awareness of who is protected, the dangerous behavioral adjustments, the emotionally driven actions caused by complaint fatigue, the inability to articulate a defense, and the catastrophic financial aftermath.
It is a terrifying minefield for any organization.
It really is. But let's pull back from the specific lawsuits and the multi-million-dollar verdicts for a minute. Let's look at the real-world application of this framework. How did the professionals at SHRM 26 react to Lessig's approach?
The data on the attendee transformation is remarkable. It really speaks to the effectiveness of structuring the conversation this way. According to the feedback sources, 100% of the 355 respondents found the session valuable.
100%.
In a room full of seasoned HR professionals who have likely sat through dozens of mandatory legal presentations over their careers, unanimous value is essentially unheard of.
Furthermore, 97% found it engaging and 94% found it actionable.
I think the key word in that feedback is actionable. One attendee left a specific review praising Lessig for taking a large-scale issue and breaking it down into doable, bite-sized nuggets.
Bite-sized nuggets. That is the genius of the 5-step checklist. It takes the nebulous fear of a retaliation lawsuit and converts it into a concrete operational safety mechanism.
It translates complex employment law into a daily management tool.
When a manager feels that complaint fatigue kicking in, when they hear that Charlie Brown teacher noise and they are about to make an aggressive adjustment or write a vindictive email, this framework forces a pause.
It forces them to stop and ask the critical questions. Wait, am I acting on objective business logic right now, or am I just annoyed? Can I articulate this decision to 8 strangers on a jury?
Am I about to create a massive financial aftermath for my company?
It empowers leaders to maintain operational effectiveness without unnecessarily risking millions of dollars.
It shifts the entire corporate focus from a defensive posture of, do we have a policy in the handbook, to a proactive posture of, are our managers emotionally and procedurally trained for the moment after the complaint is filed?
Because, as the data and the case law clearly show, retaliation is not the original spark. The initial complaint of harassment or discrimination is just a spark.
Retaliation is the gasoline that management pours on the fire. Through poor awareness of protected witnesses, reactive and suspicious adjustments to timelines, frustrated actions driven by complaint fatigue, indefensible articulation on the witness stand, and the devastating aftermath of punitive damages.
It is an entirely self-inflicted wound. The liability is created entirely by the internal reaction, not the external complaint.
As we wrap up this deep dive into the hidden danger zones of workplace management, we want to leave you with a final thought to mull over. Something to take back to your own desk or your own boardroom today.
Consider your own workplace right now. Think about the specific employee who annoys management the most. The one who is constantly raising issues, constantly forwarding policies. The one who gives your supervisors that severe Charlie Brown's teacher fatigue.
Wow, 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 wow.
Right. Are your managers currently evaluating that employee based on their actual, objective, documented performance metrics? Or are they quietly, subtly building a paper trail purely out of complaint fatigue, hoping to justify a termination down the line?
Because somewhere in your organization, a stressed out manager might be making an adjustment right now, and the clock on $1 million mistake has just started ticking.
It's a very sobering thought.
It is, but one that could save your organization millions. The legal landscape isn't about perfectly clean binary diagnoses. It is about understanding human behavior, managing frustration, and always remembering that your internal decisions might one day be judged by an outside jury. Stay vigilant, ask the hard questions, and force the pause before you act.